Hello, welcome to This Family Does Everything. My name is Alexandria. This is part 2 of Judge Dorow versus Darrell Brooks. So let's sit back, watch, and analyze the Darrell Brooks trial.
Oh, go ahead. You have your next witness.
Yes, I'd also like to move Exhibit 1C into the record, please.
Exhibit 1C is received.
Thank you.
Your objection is noted.
Can I state the grounds, if I may?
You may.
There's a point in the video that was shown, like during the interview part between the officer and the three individuals where...
That's not the exhibit we're talking about.
Well...
We're talking about 1C, which is the annotations to the map that were made that are captured by the annotation system that the state just moved in and the court received.
Okay. I didn't understand what was being referred to. I was going to bring this up, but I wanted to wait.
Sir, let's take it up outside the presence of the jury later on. You'll have to remind me later. I've already received the video, which is exhibit number 6.
That video has some language in it that you made an order on. So I just want to put that on the record. Something that you ruled on.
Sir, we'll take it up outside the presence of the jury. All right? I need to keep going on. Next witness, please.
The state will call Kyle Edwards.
All right, Mr. Edwards, please make your way to the witness stand, which is to my right. It is up a riser. When you get to the witness stand, please remain standing, raise your right hand, and my clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please be seated. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Kyle Edwards, K-Y-L-E-E-D-W-A-R-D-S.
Thank you. Go ahead, your witness.
Good afternoon, sir. Thank you for being here.
Edwards, K-Y-L-E-E-D-W-A-R-D-S.
Thank you. Go ahead, your witness.
Good afternoon, sir. Thank you for being here. Do you think you can identify the driver of that red SUV?
Yes, I think so.
Okay.
Yeah.
Do you see that person present in this courtroom here?
I do, yeah.
Your Honor, I'm going to ask that Mr. Brooks be instructed to remove his mask temporarily.
Mr. Brooks, you're instructed to take off your mask temporarily and look up, please. Thank you.
So at the time, it was a lot more dark facial hair features and longer hair as well. So, because again, I would have saw through the windshield once, but then also with the window rolled down, kind of looking back. So maybe just like the forehead and then the long, massive hair.
Sure. So different than he looks today with kind of a clean shaven or very short hairstyle.
Yes,
and
ma'am.
Scruff or stubble on his chin?
Yes, ma'am.
Okay, but you do think it was Darrell Brooks that was driving that car based on seeing him in court here today?
I do, ma'am.
Are we done with the map? I'd like to turn it
Oh, yeah, I'm sorry.
Thank you.
Do you recall who subpoenaed you here to testify?
Yes.
You stated for the record?
Yes, I said.
Do
Oh,
you-
the state of Wisconsin district attorney.
Do you see the state of Wisconsin present in the courtroom today?
Objection irrelevant.
Sustained. Mr. Brooks, move on. Under 90611, I've sustained all of the objections related to this line of questioning. It's not relevant. Next topic, or I will find that the cross-examination by you is done.
So you're sustaining every question pertaining to that part of questioning? Or is it for
Yes.
every testimony? Or
It's on that topic, so you may continue if you choose another topic.
have you ever seen the plaintiff, state of Wisconsin, before?
Right, pursuant to 90611, judge controls the order and mode of interrogation, that these questions violate sub 1, and Mr. Brooks will not be able to ask any further questions of this witness. Does the state have any redirect?
No redirect, Your Honor.
All right, thank you. You may step down.
What was
Mr.
violated?
Brooks, I'm not going to address that right now. I think this will be a good time to take our afternoon break. So we'll be, I need to address a couple things with the parties, but as far as the jurors are concerned, about 15 minutes for the afternoon break, give or take. Three notes to the court. I review them as they come in. At times I put no response needed by the court. I initial it, date it, put the time. These will be uploaded into the file at some point. There was one particular request I do want to take up by Mr. Brooks, and that is at 1:11 p.m. he sent a note to the court indicating, I'm very emotional right now, can I go to the other court? I responded to that at 1:20 p.m. and I said the court will address this at the next break. Clerk advised to provide a copy of this response to the parties forthwith. I believe she may have provided even the other note, a copy of the other note in my response at that time, but at a minimum I know my response was copied and provided to the parties. I did note that I saw Mr. Brooks reviewing the papers. They were put on the corner of his table. I wrote down the time. It's not at my fingertips. I'll look for that. But in any event, I did want to address that with you, Mr. Brooks. You've been in the courtroom. You've been meaningfully participating. Are you asking to go to the other courtroom?
At the time that we went back on the record, I was very emotional at that time. Still very emotional, but I'm attempting as best I can to hold it together. That does lead me to, since we are addressing certain things outside the...
Well, I'm addressing this first, sir. Are you making a request to go to the other
I'm not
courtroom?
making any requests at this time. Like I just stated, I'm trying my best to hold everything together considering how this day has been. I can't expect anybody else to know what's inside my head to know what I'm going through right now, but yeah, we'll just leave that there.
All right, thank you. That is noted for the record. At some point, sir, after I admitted Exhibit 6, you raised an objection. I told you I would allow you to raise that outside the presence of the jury. Now is your opportunity to do that.
And which one would you be referring to?
Exhibit 6, sir.
Or the video?
We've seen multiple videos, but yes, Exhibit 6 is a video, sir.
I think it's very clear what I was referring to in that video. The interview portion of the officer with the 3 individuals has language in it that you made a ruling about, pertaining to a whole different entire...
Which part of the video, sir?
The interview part. I'm going to say it again, as I've already said it clearly enough. The interview part between the officer and the 3 individuals.
And what specifically are you referring to? What statement, sir? I need some specificity
Do you need it
to
played?
that.
Do you need it played?
Mr. Brooks, you're the one making the objection. Please make your offer of proof so I can rule on it.
The offer of proof is that there's language said by Erica Patterson in that interview that can be audible, referring to another situation in another county. You made a ruling on that would not be admitted into evidence. So at the very least, that portion of the video that you've already admitted into evidence should be removed, or the whole video should be struck and removed from the record. And I'm saying that because of the ruling that you made, the judicial determination that you made, Your Honor.
Let me turn to the state. Attorney Opper, I don't specifically recall. If I need to review it on a break, maybe I will, but do you have any idea what this is referring to?
I do not, Your Honor. I did not hear anything.
Okay. Let me pull over here. Hold on for a second, okay? 216, I need another at Hartwell and White Rock. I have another person reporting being assaulted. Okay. White Rock, Hartwell, White Rock. Okay.
Right now we're just talking real street. Nothing is happening. There's no nice nothing. They call us and
In that recording that would violate your previous orders.
I object to that. It's very clear if the video was played that you can hear language said in that portion of the video that you clearly ruled on.
I'll review it at a later point in time. The state will need to just file that clip on a flash drive so I can review that in chambers. From my perspective, even if there were to be something, it was not offered for the truth of the matter asserted. This was to provide an account of what the officer was experiencing, but I'll review it. If there is something in there, I certainly can. It doesn't change the fact that the video itself is admissible. It might have an impact on whether it's played again for the jury, at least at that particular point. But again, I didn't personally catch that, but there was a lot going on in that video at that time, a lot of audio. There's clearly, in addition to the audio from the squad, you can hear the radio, so I will need to review it again. Mr. Brooks, I'd appreciate if you not roll your eyes at me. There was a lot going on in that video. I don't think anyone in this courtroom would disagree with me. What I'm telling you, I'm giving you the opportunity to raise the issue since you essentially didn't, well, let me state it this way. You raised it when you thought it was appropriate. I told you I'd take it up outside the presence of the jury. That's what I'm giving you the opportunity to do. What I'm telling you is I'm not going to make a ruling specifically because I need to watch the video. And so I don't think that's something you should be rolling your eyes at. That's proper for this court. It would be something that if I were to just give my ruling right now, it would be something that someone could look at later on and say, well, you just admitted on the record, you didn't hear it yourself. So what I'm telling you, sir, is I'm gonna take the time, not now during the trial, but on a break when I can look at it in chambers and keep a careful ear out for what you said, and then I'll come back and make my ruling. So that's giving deference to your request. So I don't think it warrants you rolling your eyes at me.
I wasn't rolling my eyes to you about
so
that.
With that, we're on recess. 15 minutes, everyone. The court's stepping.
Your Honor.
I could probably finish my direct in about the next 10 or 15 minutes, Your Honor.
I'll let you finish the direct and we'll reserve cross for Monday morning.
Thank you.
Go ahead.
Sir, I want to show you another item that's been marked as exhibit. Exhibit 141. May I approach the witness, Your Honor?
You may. And then if you accept exceptions to that, sir.
Will I be awarded the same?
Mr. Brooks, we'll take that up later.
Sir, can you please identify number 141?
This is a list of everyone that is named victim in this case, which count it refers to, and the group that they are associated with.
That's the summary exhibit that the court admitted pursuant to section 910.06 of the Wisconsin statutes. A copy of that exhibit will be provided to Mr. Brooks right now, and that's being handed to him by Deputy District Attorney Leslie Basie. All right, anything else we need to address before we conclude for the weekend from the state?
Yes, Your Honor. Your Honor, the state is excusing from its subpoenas.
With the court's permission, please, Officer Phillips, Kyle Edwards, and Holly Berg. Have you received any of the subpoena forms from Mr. Brooks related to any of these witnesses? Just this with. I'm sorry, I apologize because I was speaking with Miss Daisy. So she also reminded me that you were going to rule later as to Detective Guth and Patterson. So we
Do not intend to recall these individuals. We would seek to release them from our subpoenas if they are on Mr. Brooks' witness list, which he has due on Monday, and he wants them subpoenaed. We would make arrangements to have them return. I guess the question is the exclusion order. Or maybe we should wait to see his witness list on Monday.
Let's wait to see the witness list on Monday, please. That's your due date. So I expect that will be filed, and then I can take up the issue of releasing individuals from their subpoenas from the district attorney's office. And then, of course, I'll take up Monday morning the issue with Exhibit 6.
Yes.
All right, Mr. Brooks, anything from you at this time?
I'm definitely gonna have the subpoenas. Like I said, I would need to, I guess, confer with how to properly get them done and filed in the right fashion.
Mr. Brooks, I've advised you previously, I would be willing to review for completeness. You need to get those to me in a timely fashion. Your witness list is due Monday, and so I expect those subpoenas to be brought with you first thing Monday morning so I can address with you and the state how any of those witnesses who are also listed on the state's witness list, we can address the logistics of that. If they're not on the state's witness list, that's a different situation, but the state has offered for any witnesses, and the state can correct me if I'm wrong, but it's my understanding you have offered for witnesses that are on the state's witness list, that if Mr. Brooks names them, and absent, I guess, any objection by you for some lawful reason, you would assist in getting those subpoenas to those individuals.
Yes, and he wouldn't necessarily be limited to our list. We've offered, in addition to that, if there are relevant witnesses and it's reasonable to get them served, that is the southeastern Wisconsin area, we will assist in that, Your Honor.
All right, thank you. That you brought that to my attention, and I didn't quite remember that. So get all your subpoenas together, get your witness list, and the state's offered some assistance in doing that.
I do want to state that I previously touched on that whole topic, that was one of my concerns when I was compiling my witness list, was was I gonna be calling anybody that they already had on their list? If you recall, I stated that for the record. That was.
You mean witnesses they actually call, or just witnesses who are on the list?
Both.
Well, if you want to question a witness and the witness is called by the state, that will be your opportunity to do that. Generally, that's how it's done. If you are asking to then have them recall during your case in chief, we can take that up at a later point in time, but you got to have the subpoenas available, okay?
Yeah, I follow that. I was wanted it stated for the record that I had raised that issue because at that time, I still hadn't even gone through the entire witness list from the prosecution. It was 30 plus pages. That's a lot of names.
I
So
agree,
it was
Mr. Brooks. There's a lot of names, but I
pretty
actually
impossible to
extended
know.
the filing deadlines. They all have come and passed, but I, obviously, in light of you representing yourself, I extended that, and have ordered that you file your witness list by Monday. So that's how we will address that. Do you have any other issues at this time?
Yes, I do. The statement of particulars that hasn't been responded to by affidavit. The notice of special appearance hasn't been
I
responded
direct
to.
your attention to the Barnaby decision, sir. The court's not going to be addressing that topic any further.
So what about the subject matter jurisdiction?
Sir, that's an argument that has been debunked repeatedly by the courts in the United States of America, all over the place. It is not recognized as any type of issue that a court needs to address. It is summarily denied.
Can you
Next
show
topic.
proof that it has no relevancy, Your Honor?
I direct you to the Barnaby decision, sir. All right.
Can you show proof of that,
I'm sorry?
Your Honor? Verified?
Give them what?
Can you show a verified affidavit of that?
No. All right. Mr. Brooks, the hearing today is concluded. We'll see everyone back here
So
on
you
Monday
got a
at
judicial
8:30
determination
a.m.
that
We
you
are
will
in
not
recess.
answer that question, Your
Court
Honor?
stepping off the bench.
That is. As a third-party intervener in that matter, appearing as authorized representative for my client, I accept for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
All right, the record should reflect that the individual known to this court as Darrell E. Brooks appears in person and in custody. He is in street clothing today, in a suit and tie, also wearing a mask. I checked with Mr. Brooks before calling the case if he had any documentation to provide to the court or to the state. I did look at a number of subpoenas. I told him for completeness, and the one thing I noted was that there was a date and time for the appearance that was not included, and so I just wanted to address that on the record. Since, of course, this is a multi-day, multi-week trial, typically individuals, whether it be the state or a defendant, would put the first day of trial on the subpoena unless there was some other information to suggest a different date. Obviously, we've already started, but I can ask the state if they, given kind of how things have been proceeding thus far, I know originally you had thought it would take 5 to 7 days for you to present your case in chief. Are we still on target for that from when we started the taking of testimony?
Yes, from when we started the taking of testimony, yes. Right now, we are projected to wrap up our case Thursday afternoon or Friday morning. So that would be within that 5 to 7 day range, Your Honor.
All right. Certainly would be reasonable if you picked a date, either Thursday or Friday, if they show up, which presumably they would, right? If we're able to get all of these, not me, but if the state's able to assist, given what they've said earlier in getting the subpoenas out, then even if we weren't quite to that point, I can certainly bring people in and let them know when to come back. And that's pretty typical.
So, Your Honor, just so I'm clear, so I put, so that would be roughly the 13th or 14th?
Today's the 10th, so Thursday would be the 13th and Friday would be the 14th. And then I didn't look very close to the names and whether you had addresses, but you should put in their last known address or other information as to where these people can be served if you know.
I was going to mention that too. That's kind of problematic because a lot of them, their addresses are not stated in the paperwork. So I don't
Are
know.
all of these individuals referenced in the paperwork that you've reviewed?
Yes, they are.
All right. Presumably then, Attorney Opper, you'd be able to look at that and perhaps assist with that information?
Yes, to the best of my knowledge, everyone's address is somewhere in the paperwork, but yes, I'm sure we will be able to find addresses.
The other omission I noted, and not necessarily your fault, is these were stamped by our clerk of court, which is standard. I will direct my clerk with your approval to put today's date for the date that these are all signed by the clerk of court's office, okay? Is that a yes? I thought I saw you shake your head yes. I just want to confirm for the record. Okay.
I mean, it's just a lot of this that I expressed last week that I wasn't really sure how to get done. So whatever assistance is greatly appreciated.
All right, so Madam Clerk is directed to put in the date at the top left, and then what I'll do is I'll keep a copy for the court's records, and then give you a copy, and then we'll give the originals to the state so they can look over them and then tell us if there's any issue with trying to get them served. But I need to get that to them this morning with your approval so they can let us know if there are any issues. Do you agree to that, sir?
Yeah, I just got to put the dates in then, correct?
Yes, yes. It would be fine if you did Friday morning. I mean, even if the state got done a little bit early on Thursday afternoon or something, and we, in theory, had time to call a witness, I'm happy to just go to the next morning so that it's clear.
What should I put for the time?
8:30. And then just let me know when you're done so I can address a couple of other issues. Copies of those. If you tell me the number, I can also look that other thing up. I'll just pour it if you give me the number so you can make the copies. 153, 150. All right, while Madam Clerk is copying those subpoenas so that the court has a copy, Mr. Brooks has a copy, and then the originals go to the state to review and assist with service, I do want to address Exhibit 6.
What? What? Black guy, red SUV just assaulted my friend in the park. Oh, shit.
This guy, he not hit me, so they called the cops.
You guys involved with a knife or something?
You can check me.
Okay.
Nice.
Okay.
I've already been slashed with the knife.
Let me pull over here.
Yeah, what the
One 22, of their car, red through westbound, 15, I need another at Hartwell and White Rock. I have another person at 48 something. Okay. White Rock, Hartwell, right.
Me and my baby daddy, we argued over food.
Okay.
They understand when he ran me over with a car. Right now we're just talking about food. Nothing is happening. There's no knife, nothing. They call for me to argue.
Which was previously received by the court. This is the 6-minute squad cam and audio footage from Officer Phillips. As I advised last week, after I went back into chambers to review that, I did note what Mr. Brooks had said. I may have been a little bit off on the language in terms of what Ms. Patterson is heard saying, but it's a pretty clear reference to one of the incidents that is the subject of a prohibition by this court related to other acts. And I indicated I was inclined to strike that exhibit, and so advise the jury, but I would give the parties an opportunity if they had any arguments on that to address that this morning. So since the state offered it and there is that violation, I'll turn to the state.
Thank you, Your Honor. First, I do offer my apologies to the court and to Mr. Brooks because the previous occasions where we had watched that video, we did not catch that. I think the record will speak for itself, but there was a lot going on in that video. As you had mentioned previously, the officer's radio was talking. You can hear the dispatcher, you can hear other officers, and you can hear some people talking in the distance as well. So we did mistakenly include that. However, that being said, Your Honor, I think it's a clear reference to the other acts only if you know there's other acts. Truthfully, I think it's a vague and ambiguous statement. What I heard the statement to have been at about the 2:52 mark in the recording, I heard Miss Patterson say, "Me and my baby daddy, we fight all the time. We had an incident, he ran me over with a car." That's what I heard her to say. She does not say it happened in Milwaukee. She does not say it happened 3 weeks ago. She does not say I suffered a broken leg. To me, in the context of Miss Runkle's testimony last week, in which she testified that Mr. Brooks had swerved at Erica Patterson, and that Miss Runkle had pulled her out of the way, I don't think the jury would have immediately thought Erica Patterson, when she made that statement, if they heard it, was referring to something weeks earlier in another county at another location. Really, the only thing objectionable about that whole quote I just issued would be the very last phrase, "He ran me over with a car." And again, if she's referring to the Milwaukee incident, it's not clear from that statement. I certainly understand with the knowledge of the Milwaukee incident, there's a reasonable interpretation that's what she was talking about, but she may also have been talking about the events of November 21st, even to an objective standard on this record, Your Honor. I don't think the jury would have realized or appreciated she was talking about another incident. So I think the exhibit can stand as is. We could redact just about a 2 or 3 second audio from that recording where those words are removed, and I listened to it several times over the weekend. I think if we did that, it would not be that obvious, so that the exhibit could stand in place. The officer, if you recall, the timing is he's getting out of his car and he's approaching them, and she makes that statement about "he ran me over with a car," but then her very next sentence is, "There's nothing happened, nothing's going on, nothing to be worried about here." And she's essentially trying to convince the officer not to do anything. So again, I think that also supports our contention that if we strike the exhibit or we strike words from the exhibit, we may be calling undue attention to something that was very vanilla to this jury that they really wouldn't have thought twice about, given the testimony of Corey Runkle and Erica Patterson that was already on the record. So we would offer to redact that portion if appropriate, but it may also be appropriate just to leave it stand as is. And should they ever ask to see that exhibit again, we would prevent that from being played a second time.
Thank you. Mr. Brooks, do you have a position on this?
Yeah, I mean, it's obvious to me. I can only hear out of one ear, and I was able to hear clearly what was said. With all due respect, Your Honor, you made a ruling about this previously, in ample enough time before the trial even started. You made the ruling. I see no reason why the exhibit should be admitted into evidence. From my perspective, it's clearly obvious what was being referenced. I mean, if she was able to give any type of statement at that time to the officer, then obviously she wasn't hit at that time on that date, on the 21st. She would clearly be referencing some other incident. Hence the reason why we argue all the time in this, that, and the third. It was clear to me what was being referenced, and because of the ruling, because of the implication in that statement, I believe the exhibit should be striked altogether.
Thank you for your position, Mr. Brooks. And the reason why last week I said I'm inclined to strike it, but I wanted to give the parties an opportunity to review it over the weekend is, in some respects, because of what the state just said. There's information on that clip, at least from Ms. Patterson, that I didn't know if you wanted to come in or not, about nothing happened here, right? Those types of statements. So that's why I give the parties a chance to look it over and then come back to court and tell me what they want to do. So your position has been made clear. You believe it should be struck or stricken, as we say. And I agree with you, Mr. Brooks. This court gave a very clear prior ruling related to other acts, and the state had an obligation to abide by that ruling. While I have options available to me, meaning I could redact it if the jury wants to hear it later on, my concern with redaction is it may possibly highlight that portion. We don't know whether any one of these jurors heard it and made a note about it. And that's certainly not something I'm going to ask them to reveal. And because of the violation, and even though there's other things going on, even though I could redact, I am going to strike this exhibit and so advise the jury. As far as advising the jury, I simply want to tell them the following when they come into court today. As previously, the court received Exhibit 6 during the testimony of Officer Phillips. The jury is hereby advised that the court has stricken this exhibit, and the jury is to disregard anything it may have heard regarding what was on that exhibit. Any objection to that language from the state?
No.
How about from you, Mr. Brooks?
No.
I know last week I also had indicated I had asked the Sheriff's Department to prepare an incident report regarding one of the occasions Mr. Brooks was removed from the courtroom. I've been advised it's been dictated and I believe written. I haven't seen it yet, but I did follow up on that this morning. I believe I'll have it at some point today, and we'll turn that over to the parties.
In reference to the 6th, Thursday, October the 6th.
that was in reference to the incident where, if my memory is correct, where there was not about the COVID test, but about the needing you to sit down so that, I don't remember if you were over there or here or what, but they needed to get those restraints either on or off so that you could be situated, and that's where you had indicated you had been hurt. So that's what I'm talking about. I wanted to have a record of that here.
I think that was the 6th. I also want to state for the record that I was given paperwork to fill out a report of my own, and I stressed that because after the detectives came and took the pictures of my bruises and injuries, I was told that they didn't know when I would actually get the actual filing of the report that they were going to report. So I just went ahead and asked for my own. I filled that out. I don't know if it's been given to the right parties yet.
You're talking about the inmate complaint form to have the either the jail or the sheriff's department review that related to the use of force.
Yeah, it was the top paper was from the sheriff.
All right, you know that that's not my responsibility to address what happened other than how it impacts this trial, which is why I wanted to have a record. If there's anything you believe should be in the record from you regarding that, then you should turn that in. Okay. All right, I didn't have anything else on my list of things. I don't know if the state does or Mr. Brooks, so I will ask the state first. If there's anything you believe I should address prior to the jury coming things, I don't know if the state does or Mr. Brooks, so I will ask the state first. Things, I don't know if the state does or Mr. Brooks, so I will ask the state first. If there's anything you believe I should address prior to the jury coming back out.
Yes, Your Honor, I would ask that some of the witnesses that testified last week be released from their subpoenas, especially now that we have Mr. Brooks' witness list. Specifically, I'd be referring to Corey Runkle, Officer Phillips, Kyle Edwards, Holly Berg. I note on his list today he does still have Erica Patterson and Detective Guth. At some point, we'd like to be heard about that, but we don't need to delay the jury at this point.
All right, any position on their request, Mr. Brooks?
I guess my objection to that would be Officer Phillips. That would be one that I would still like to be under subpoena. Everybody else is I'm fine with.
That's the officer whose squad video I just struck. So you didn't have him in your subpoenas. So you'll need to, for now I'll tell the state they can't release him. You'll need to fill out a subpoena, and I need to have that by the lunch hour today in order for him not to be released from the state subpoena.
And I definitely don't want Erica Patterson released from.
Right, you have her on your subpoena, so I understand that.
I just wanted that for the record.
All right, thank you. All right, then I will grant the request from the state as to Corey Runkle, Kyle Edwards, and Holly Berg. For now, Officer Phillips will remain under the state subpoena along with Erica Patterson and Detective Guth. We can take issues up with that either, maybe closer to the lunch hour or when we come back, or even at the end of the day. But I would like to bring the jury out. But of course, Mr. Brooks, I need to turn to you first and see if there's any issues you believe the court should address.
Very briefly, I just want to state this for the record that I would like to issue the court an apology from me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial. The families here that have to go through, everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that. I wasn't raised that way. And I owe you, Your Honor, and the court an apology, and I'm going to stand up as a man and tell the whole court and you, Your Honor, that I apologize to the bailiffs, that I apologize for my actions. Like I said, that's not how I was raised. I come from a Christian background. My mother did not raise me that way. She did not raise me, to act out of frustration and irritation and anger. And I just wanted everybody to know that I apologize for my actions. And I'm going to try my best to, whatever happens, to everybody here. I just wanted y'all to know that.
Thank you, Mr. Brooks. I do appreciate that. Understandably so. This is an emotional experience, I think, for everyone involved. And I appreciate that you, upon reflection, have realized that courtesy and decorum are an important part of a court proceeding. I know that despite you being emotional at times and not being an attorney, you certainly, you're clearly paying attention. You've made some very salient points throughout the last few days. I think you're settling in quite well, and we're going to keep this trial going. I know you said earlier, and I just want to make a record of this because it's really important that I do this, sir. You've mentioned repeatedly about your hearing. I know you don't have the headphones on now. We'll give them to you just based on what I've observed this morning and how you've responded to things that have been said. I think you're hearing us, but if we haven't made the headphones available, we got to make sure we do that every single day so that if you need them. But I do appreciate everything that you've said. And I know we have Detective Casey, who will bring up momentarily for your cross-examination. Just so everyone is aware, it's my practice when there's a second day to also put the witness under oath. I'll wait till our jurors have their notes ready. And good morning and welcome back. Hope you all had a very nice weekend. Previously, the court received Exhibit 6 during the testimony of Officer Phillips. The jury is hereby advised that the court has struck this exhibit. The jury is hereby advised to disregard anything it may have heard during the playing of Exhibit 6. With that, we have Detective Casey here for cross, as is my practice when there's a second day.
Do you recall how fast the vehicle was going at the time you attempted to stop it?
I believe the vehicle was going about 3 to 5 miles an hour when I tried to stop the vehicle, and it continued on past me.
Would it be fair to say that 3 to 5 miles an hour is not very fast?
I think it's very fast when you're in a parade route, when there's hundreds of people marching in the road and a police officer is standing in front of your car, pounding on the hood, trying to get the vehicle to stop. I'd say that that's too fast. Any speed is too fast on a parade route when you have all those people in the roadway. A car should not have been there.
That wasn't the question, but thanks for the commentary.
Detective Casey, please just answer his questions. Attorney Opper will have an opportunity to redirect if necessary.
Would it be fair to say that that's not a very fast speed?
Objection, asked and answered.
Sustained.
Do you recall if the operator of the vehicle that you gave a description of had any hair on her head?
I do not recall seeing the operator's hair that day.
So it would be fair to say you don't know if they had long hair, short hair, anything of that nature?
That is correct.
Do you recall testifying at the preliminary hearing in this matter?
Yes, I do.
Can you recall what you said when asked a description of the driver of the vehicle you attempted to stop?
I don't recall word for word what I said.
Do you recall being asked the question?
I would think that I was, but I don't recall the exact words that I used then.
Just 1 second. Do you recall saying that the operator of the vehicle you attempted to stop had short hair and a short dark beard?
I'm not sure what the context is, but I don't recall saying that the person had short hair.
The context was the question of, did you get a description of the driver of the vehicle you attempted to stop?
I guess I'm not sure when you're speaking of, because was that when I saw the car or when we saw the vehicle after what witnesses said? It seems like I'm not sure exactly the time period that
So
you're
are we
asking.
talking about what witnesses said or what you actually saw?
Correct, that's what I'm confused about.
Well, you just said that you recall being asked at the preliminary hearing that you testified at a description of the operator of the motor vehicle. Would that be fair to say?
I don't understand your question.
I think it's very clear. You testified at the preliminary hearing in this matter, correct?
Yes, I did.
And were you not asked a description of the operator of the motor vehicle that you attempted to stop?
So I believe my testimony was at the preliminary hearing that I did not see the person's hair, if that's the specific time that you're speaking of.
I have a portion of that preliminary hearing that you testified at with your words right here.
Mr. Brooks, what page are you at?
I am at page 17.
All right, thank you.
You were asked, could you see anybody inside the vehicle? Your answer was, at that point, I could not see the person real clearly, but as the vehicle continued pushing through me, I was paused. My position changed to the side of the vehicle where I was directly outside the driver's side window. And I could see inside of the window and I could see the driver very clearly. Would that be fair to say that those are your statements?
Yes, sir.
So, could you or could you not see the driver clearly?
Your question is if I could see him clearly. Yes, I could see him clearly.
So why would you state that you couldn't see him clearly when asked the question?
I think you're asking about his hair.
No, I asked about his hair before. This is a different question.
Could you ask your question again, please?
You just stated that you could see the driver clearly, correct?
Correct.
But you also said that you couldn't see the driver clearly, correct?
Objection, that's a mistake.
Grounds.
So, Mr. Brooks, I think it comes down to a little bit of context. I'm going to sustain the objection, and then if you would please rephrase. I think it comes down to at what point in time in the contact with the SUV are you referring?
At any time.
Your Honor, we need the question again. That question is vague.
Right. Put it all together, if you would, I'll sustain the objection.
At any time, could you see the driver clearly? At any time during your attempt to stop the vehicle?
Yes, at any time I could see the person clearly that was driving.
The entire time you attempted to stop it, you can clearly see the driver of the vehicle?
Well, at one time you asked any time, and then you asked the entire time. So
Detective Casey, just answer the question, please, if you can. If not, say you don't understand it.
I don't understand it.
Just a second. Have you ever had any interaction with the plaintiff in this matter?
Objection, irrelevant.
Grounds.
Sustained.
How long have you known the plaintiff in this matter?
Objection.
Grounds.
Let her get her objection out, Mr. Brooks. It's sustained on relevance grounds.
Well, I do respect, Your Honor. I think that those are valid questions to the matter.
Mr. Brooks, they've been sustained. Next question.
I want to refer you again to page 15. It is from your testimony at the preliminary hearing.
With Your Honor, that's improper because Detective Casey does not have the testimony transcript in front of him.
The district
Grounds.
attorney is correct. This witness does not have the transcript in front of him.
So would that render him unable to recall what he testified to?
I don't know. You have to ask him that.
That's what I was attempting to do, Your Honor. I apologize. So just so I'm clear, am I allowed to read from this or no?
Just ask your question, Mr. Brooks.
From the best of your knowledge, do you recall stating in your testimony at the preliminary hearing that it was in fact the vehicle you attempted to stop that was blaring its horn?
Objection, that's not what the
Grounds.
transcript says.
Grounds.
And it's been asked and answered.
Sustained. They were before. State may call its next, well, actually, we'll bring the jury in and then you may call its next witness. Seem to like to want to do that these days. All right, have the jury brought back out, please.
I'll state very briefly for the record, Your Honor, that we still have yet to address the subject matter jurisdiction. Would that be addressed at some point?
Mr. Brooks, that's a frivolous matter. We've already addressed that. I direct your attention to the Beneby decision, United States versus Beneby, found at 654 F 3rd 753. So I have addressed it.
Is that a judicial determination, Your Honor, that you want to address the subject matter jurisdiction?
The record stands, Mr. Brooks.
Would a verified statement of particulars by affidavit be addressed, Your Honor?
All rise.
Is that a tacit agreement, Your Honor?
I think it's pretty clear. Want to redo, we'll give you, do you have new forms, Madam Clerk? So we can, do you have
Not
extras?
Sitting right here.
What was that?
Not sitting right here.
Okay. Do you have any extras? I know we've given you a bunch, or do you need new forms?
I really only brought the ones that I was required
okay.
to turn in today.
That's okay.
So.
What we'll do is we'll make sure on the next available break, I'll have my clerk count off how many there are. We'll get them reprinted. I think they keep forms in the clerk's office, and then put the date on, and then you can fill them out again, and then we'll hand them back over to the state. Do you intend these subpoenas to be the equivalent of your witness list, or were you going to file something separately?
I was intending for this to be my witness list. I think that would probably be easier.
Any objection from the state?
No, we understand. I think we've been given fair notice, Your Honor.
Okay.
I do have some other challenges on some of these subpoenas, not, again, that we need to necessarily address right now, but I would like to advise the court and the defendant that he's requested a subpoena for a person identified as Sammy Fleischman. We have learned that Ms. Fleischman has relocated to the state of Texas. Therefore, we will not be able to secure her appearance here at the trial on behalf of Mr. Brooks. If he wishes to make arrangements for transportation for Ms. Fleischman, he may do so himself. Ms. Fleischman, it is my understanding, was the woman who organized the parade, or was one of the people that organized the parade, but that's how she's identified in the reports, and therefore her relevance may or may not be an issue as well.
All right, did you hear the state advise you of that?
Yeah, I wouldn't even begin to try to know how I can do something like that from a jail cell. I'm pretty much broke.
Well, you're advised, though, if she's out of state, there's other procedures would have to be followed, and the state is not obligated to make those arrangements since it's an out-of-state witness at this point, okay? Did you hear me say that?
I follow.
All right, thank you. Anyone else in the subpoena list?
I mean, there's others that we have objections to, but I don't know if you want to address that right now, Your Honor.
Well, I'd like to have you put them on the record so that Mr. Brooks knows, and if he wants to respond now, that's fine. Otherwise, we can take it up a little bit later.
The other two would be Erica Patterson and Detective Steve Guth, seeing as they have already testified and were subject to cross-examination. We would request an offer of proof as to what relevant testimony, if any, they may offer. And then there was one of the parents of the victims, Kathleen Urell. She was not present at the parade. And it's really unknown what type of testimony he would want to elicit from her. So we would be requesting an offer of proof to establish the relevancy of those witnesses, Your Honor.
Do you want to address that now or have an opportunity to think about that and address it perhaps at the end of the day?
It's really nothing to think about. I think it's pretty clear. They are, besides Miss Patterson and Detective Guth, I mean, as far as with them, I think it would be relevant because we have paperwork that was filed by the district attorney about there being no factual basis nor no domestic violence incident on November 20th, which they testified to. I think that that's perjury. So that should be...
Well, you're giving me an argument, I guess, on the relevance of their testimony, sir, but as I recall the testimony, you are the one asking the questions about the 20th. The state dismissed that charge. I granted that request to dismiss it. There's nothing that you are bringing to my attention that I can tell would be perjury, but I don't know if what you're trying to tell me is you'd like to question them about their credibility because that charge, explain to me a little bit further.
It would be a lot to do with credibility and also a few questions that I believe would still be relevant to even the events of the 21st. There's still some relevant things that I feel should be answered, that I feel the jury deserves to know.
Well, I'm going to give him some leeway. He's a pro se defendant. He has a right to call witnesses. These are two witnesses that testified. He did have the opportunity to cross-examine them, but I think it's reasonable for him to want to question them further, and I'll keep them on your witness list and instruct the state to assist as they have already offered. What about this Kathleen Urell? I know she's on their potential witness list that was filed.
To correct, I apologize for interrupting, but I did misspeak. She was at the parade, but she did not see, she cannot testify to anyone being struck or injured by the SUV other than her own children that she learned after the fact. And she cannot identify the driver.
All right, Mr. Brooks?
It's still relevancy there. She was at the parade, and as we just heard right now for the record, that she would be directly affected by it, by her family being victims in the matter. Also, she gave statements and she filed a report. I feel like her testimony would be relevant to the matter.
All right, I'll keep her on the list as well. Anyone else on the list of subpoenas?
No, Your Honor, we'll just await to receive the corrected subpoenas and then we will endeavor to have them served.
All right, thank you.
Just
Thank you.
one thing real quick, Your Honor.
Go ahead.
And if I'm misspeaking right here, feel free to correct me. You said something to the effect about getting more paperwork in during the lunch hour. What was that referring to? Was that referring to the subpoenas?
I believe it was referring to a witness list. If you had one, but what you're indicating is you'd like the grouping of subpoenas and the witnesses who are identified to be reflective of your witness list without filing an independent witness list.
Well, I missed this subpoena. It's only one, but I would have to change it because it was filled out in the same way as the other ones. My mistake for missing it. I got a lot of paper.
What's
here.
the name on it?
Catrice Babayis. I don't know. It's spelled.
All right,
I don't want to butcher it.
That's okay. Hand it to the bailiff, and then I'll take a look at it.
It's filled out in the correct. The incorrect, just like the other one. So I would have to essentially change it. But I just wanted that for the record that was lurking in my paperwork.
That's okay. Thank you for providing that. The last name is Babiasz.
Yes, we're familiar with that witness. Thank you, Your Honor.
All right, we'll add that to the list. State still have the originals that I handed over to you?
I do.
All right, why don't we give all of those back to Mr. Brooks so that he has those, including the one in my hand. We'll make sure he gets new forms. And then if you could just make sure you provide those at the end of the day today, or by the end of the day.
Well, I don't know if I'll be able to fill all those out on a break.
If need be, I'll let you sit here at the end of the day until you get them filled out, so to make sure the state gets them right away. Okay?
I can try to knock out as many as I can during the breaks to make it easier.
We'll
But
give you time.
I'm not sure that,
We'll give you time. Don't worry about it. All right, anything else from the state?
No, thank you.
Mr. Brooks, anything else from you?
Yes. At this point, I'm probably beating the dead horse, but I just have to stay for the record anyway. I would like to direct your honor to, I believe it's Milo versus United States, 505 F2D 1026. Are you familiar with that, Your Honor?
Not off the top of my head, but I can pull it up.
And also Hagens versus Levine, 415 US 533. And those cases are being brought up because of the continuing asking of me about the jurisdiction that I've been challenging. I believe they're very, very relevant to this matter.
repeat those numbers again?
For both,
Yes, please.
for Milo, I believe it is, or it might be Milo, but Milo,
M-I-L-O?
Milo,
Is it M-I-L-O, the spelling?
M-E-L-O.
Oh, I had it right the first time. Okay.
505 F2D 1026. And Higgins versus Levine 415 US 533.
Anything specific you want to draw my attention to?
Well, there's cases that challenge the jurisdiction, which I've been doing, challenging the jurisdiction. Milo versus United States states once jurisdiction is challenged, the court cannot proceed when it is clearly appears that the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action.
For the record, Mr. Brooks, the Higgins versus Levine is 415 US 528. Perhaps
Whoa.
you're drawing my attention to page 533, but the site for the case is 415 US 528.
That could be so. I apologize if I'm stating it wrong.
What about the other
I
case?
believe it's, well, the information I have is 533. That states the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. We have yet to prove the jurisdiction. It has yet to be proven. I've filed a motion. I've stated on the record numerous times. I have yet to get an answer.
And you're specifically referring to the documents you filed on October 3rd.
I've been challenging jurisdiction since the beginning of trial, probably as far back as when I became a pro per defendant myself. Also, you can look at U.S. versus Lopez. You can look at, I think that's from, it may be from 1995.
Do you have a citation?
Just really quick. I may have to find it in my paperwork for the Lopez.
All right, well, you locate that. When you find it, let me know outside the presence of the jury. I'll take your request under advisement. I'll take a look at these cases. I don't believe they're going to change my previous ruling that the issues that you have raised are without merit as previously ruled on. But I'll take a look, and if I feel I need to address it further, I'll give you an opportunity to argue.
I believe it should be addressed. Thank you, Your Honor.
All right. Then with that, we are still going to continue, Mr. Brooks, and we'll bring the jury out. I presume the state has the next witness available.
Yes.
All right, Madam Clerk. Okay. Did you say you thought Lopez was from 1995?
I believe that's the one that it's referring to.
If it's the same case, it's 514 US 549 for the state.
514549.
514 US 549
Thank
from
you.
1995.
Thank you.
And did you file a claim in this matter? Any type of claim?
Yes.
What was that claim?
There were claims that were filed with the state of Wisconsin that were to cover like the cost of the medical treatment that was received.
So the state of Wisconsin offered to pay your medical expenses.
It was through the Victim Witness Protection Program.
So would you consider yourself a party to this matter then?
Objection.
Grounds.
Sustained, not relevant. Excuse me.
And in the claim that you filed, did you file a claim under an injured party?
Objection. I guess I'm not
Grounds.
understanding the question. It's vague.
Grounds.
She indicated she filed a claim because she was injured.
So
Mr. Brooks, I'm sustaining the objection as to the form of the question. Please rephrase.
do you consider yourself an injured party?
Yes.
Are you a plaintiff in this matter? Grounds.
She's a witness. Sustained.
Have you read or seen a complaint in this matter at any time?
Objection is to relevance.
Grounds.
Overruled. She may answer.
I'm sorry, what was the question?
Have you seen or read the complaint?
No, I don't know what complaint is being referred to. No.
And were you aware that you may be called to testify in this matter?
Yes.
And who were you informed by?
The Victim Witness Program and the prosecutors.
So are you saying the state of Wisconsin?
Objection is to relevance.
Grounds.
Sustained. Mr. Brooks, under item 611, please move on to another line of questioning. Thank you, ma'am. You may step down. She may. You may call your next witness.
The state calls Sarah Waymeyer Aparicio.
All right, we are back on the record. Appearances are as they were before. We'll bring the jury out for cross. Go ahead.
For that, Your Honor, can we address the subject matter jurisdiction, please?
No, not right now.
Is that a judicial determination, Your Honor?
discussion outside the presence of the jury before our next witness, Your Honor.
Okay, very well. I'll excuse the jury. All right.
The next witness is Thomas Green. This is the witness that we previously raised the issue about having one prior criminal conviction. It's from 2005. A CCAP printout was provided to the defendant for the misdemeanor offense of criminal trespass. The offense date is from 17 years ago. The witness was 21 years old at that time. He's now 38. Has no other intervening criminal convictions. Was not originally a crime of deception. I believe that it's not relevant for purposes of impeachment. I'd ask the court to exclude that conviction from this witness's testimony.
Mr. Brooks, do you have a legal argument on that?
Yes, I do. The main thing is this issue wasn't really discussed to this length until it was time for this witness to be called to the stand.
Well, that's when I said I would take it up, is prior to that witness's testimony. I even gave you the statute that is at issue, and it's 906.09, impeachment by evidence of conviction of crime or adjudication of delinquency.
Here's
pull
why.
the statute book out, and it's in there. If you want to review it quickly, I'll give you an opportunity, but I do need to address this, and now is the proper time.
906.09.
There's a general rule in sub 1 and the exclusions under sub 2 and the factors for the court to consider in evaluating whether to admit evidence of a prior conviction for the purpose of attacking a witness's truthful character. Before I have you address it, let me ask the state this. How long do you anticipate your direct examination to be?
10 minutes.
All right. So someone we could and should be able to get through fairly quickly,
Yes.
both for direct and cross. All right, go ahead, Mr. Brooks. What's your argument?
I'm still. I wanted to make sure I heard what you said, so I stopped reading briefly. I guess I would, from what I've read so far, I would go to 906.09 sub 2. It would be kind of problematic, and I'll say that because if I was going to take the stand, my record would be brought up, and some things on my record was done 20-something years ago, but it would still have bearing. So I believe that it should be fair. It should be the same. I believe that if the witness knew that there was a possibility that they would give testimony and agreed to give testimony, then they also agreed that their credibility can be questioned. I think that's really a fundamental thing to be able to cross-examine on my part would be to see if they're credible, to see that they would honor their oath that they give in the court to be truthful. And part of being able to ask them questions like this pertaining to a criminal conviction would be relevant.
You do understand the inquiry is limited to the following. Have you been convicted of a crime? The answer I allow is yes. They would say yes. The follow-up would be, if so, how many times? And in this case, my understanding is there's just one. Don't get into the specifics of it. That's not proper questioning for impeachment. Do you understand that?
I follow.
All right, let me hear from the state in response.
So again, looking at the factors under 90609 sub 2, just about every factor weighs in favor of not informing the jury of this conviction. We've got a conviction date of April 4th of 2006. So we've got, again, well over a decade before the conviction. We've got whether this witness was rehabilitated or pardoned. According to the CCAP records, there was a probation sentence and probation was discharged, so there's no indication that this witness was ever revoked from probation, and there's no re-offending evidence or any new cases or any new convictions. So that, again, that factor weighs in favor of not including this. Gravity of the crime, this is an entry into a locked building or construction site, contrary to 943.15 sub 1, so it's a misdemeanor offense, so that weighs in favor of not including it. It does not, on its face, involve any dishonesty or false statements by the witness. Frequency of the conviction, again, it's just the one. And in terms of any other relevant factors, as an offer of proof, I'll inform the court that this witness is going to testify about his and his family's presence near the Martha Merrill's bookstore on the day of the parade, the positioning of his children, and what he remembers in terms of the SUV driving along the parade route and clipping his two children who were seated on the curb watching the parade. There's 2 videos of the driving conduct in question. They are not, they're not as clear as some of the videos we showed with the band. In fact, one of them is the video we showed with the band, and you can see spectators sitting on the side of the road. But in terms of impeaching the witness, I think Mr. Brooks should be fine just relying on the videos in asking the witness about that.
I object still. Entering into anything with is deceptive in nature. Just right off the bat, that's deceptive in nature. Why would you enter into something that you're obviously not supposed to be into? You entered into something because you were not supposed to be in there. That's deceptive in nature. It's also not enough information that would suggest that the probation wasn't discharged by revocation. It's not clear. And also, the prosecution just stated on record that they will only need about 10 minutes of testimony from this witness, but now they're talking about videos. That seems like it's going to be a little bit more than 10 minutes. I feel that I should be able to at least question the credibility of this witness at the very minimum.
Well, you would be able to question the credibility just through cross-examination, but let me get to the heart of this issue. And the general rule is as follows. For the purpose of attacking character for truthfulness, a witness may be asked whether the witness has ever been convicted of a crime or adjudicated delinquent, and the number of such convictions or adjudications. If the witness's answers are consistent with the previous determination of the court under sub 3, then no further inquiry may be made unless it is for the purpose of rehabilitating the witness's character for truthfulness. The sub 2 then of this statute talks about exclusion. It says evidence of a conviction of a crime or an adjudication of delinquency may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Factors for a court to consider in evaluating whether to admit evidence of prior convictions for the purpose of attacking a witness's truthful character include the lapse of time since the conviction, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So as I consider all of that, I would include in the any other relevant factors that this is a witness that has been brought to testify by the state against the accused. This conviction is for a misdemeanor offense of criminal. Can I have the exact? I wrote down criminal trespass, but I just want to make sure I have it accurate.
Yes, the statute in question is 943.15 sub 1. And it's listed on CCAP as an entry into / onto building / construction site / room.
All right, so a version of criminal trespass. All right. Apparently, the particular witness, this was 17 plus years ago. The witness was 21 years of age, was sentenced to probation. Nothing on the record before this court suggests that probation was revoked. I'm not aware of any reoffending, meaning that's the only conviction for this witness. This is a witness in this case who will apparently testify about where he was seated with his family in relation to the driving of the red SUV through the parade in front of Martha Merrill Bookstore. So clearly relevant to the case and the charges at hand. When looking at whether evidence of a conviction of a crime may be excluded, and specifically in this case, if its probative value is substantially outweighed by the danger of unfair prejudice. I think sometimes we skip over that part of the statute, which is the standard this court must look at, not just the factors, but whether in light of those factors, is the probative value substantially outweighed by the danger of unfair prejudice. As I commented on earlier, the nature of the inquiry is very limited. It's, have you been convicted of a crime? Yes or no? And then how many times? In that case, it would be, in this case, it would be 1. In light of that, and the other factor that I noted, even though there's some factors that I could say would warrant exclusion, I think it's best to err on the side of caution, as we sometimes say, and allow the witness to be questioned about this prior conviction under the statute, and that is the very limited inquiry of have you been convicted of a crime? The answer should be yes, and then how many times? 1, and that's it. Mr. Brooks, you may ask a single follow-up on that is it true you've been convicted of 1 crime? But we're not going to spend a lot of time on that. That's going to be my caveat to all of this. You cannot ask repeated questions of this witness about that. The jury will further get instructed later on about the purpose of a prior conviction, that it bears solely on credibility, and then ultimately it's up to the jury to determine whether or what to believe. So that's my ruling on this. Now with that, it's now 4:15. Would you like the witness to testify today?
Yes.
All right. Any questions, Mr. Brooks?
No, I was just going to say, what if I just wanted to, what if I didn't really want to go into it? What if I just wanted one question just to say, have you ever been convicted of a crime, and just left it at that?
That's fine. I'm sure the state's going to ask the questions first, though. That's typically how this goes. All right. Bring the jury out.
I just need a moment to
Understood.
this.
Understood.
I don't have any other questions. Thank you.
Go ahead, Mr. Brooks.
You stated that all the videos you just saw were accurate depictions of what you observed that day, correct?
Yes.
Have you seen any of these videos before today?
No.
So today's your first time seeing any of this footage?
Yes.
Mr. Green, have you ever been convicted of a crime?
Yes.
Do you remember what you did when the vehicle passed you?
Yes.
I think we're all set. Thank you, Your Honor.
All right, thank you, sir. You may step down.
Thank you.
And Your Honor, may we please excuse this witness?
You may. This will be our last witness today. I will have the instruction for the jury before I excuse you to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. We'll see you tomorrow morning. All rise for the jury, please. All right, thank you. Be seated. Anything else we need to address today from the state?
Matter, the defendant did raise an issue where he cited 3 cases regarding jurisdiction of this court to hear this matter. I have had the opportunity to review those 3 cases. I am able to address those now if the court wishes.
I'd like to address them tomorrow morning. I frankly need to read them, so. All right, anything else from the state?
No, thank you, Judge.
Mr. Brooks?
Just so I'm clear, on these subpoenas where it says you are further required to bring with you the following, do I leave that blank or what should I put there, just so I'm clear?
I can't give you advice on that. I only wanted you to understand that witnesses would not generally have their police reports or statements made. Those are usually kept by the police department. And so you would need to subpoena the custodian of the police records in order to get copies of that. If you think there's something else that they have that would be in their possession and that's relevant to this case, that would be different. So I hope that adequately answers your question.
I don't understand, but
if there's something specific, you can ask the state if there's some follow-up based upon the discovery that you have. But you should have everyone's statements.
I guess the only thing so should I bring your statement? I mean,
I don't know that they would have it. What I'm telling you is you should have every statement in that box, or you should subpoena the custodian of the police records, or ask the state if you think you're missing something.
I'm clearly missing something. I don't know what to put right there.
That's the best I can do for you, sir. I can only review them for completeness. The state referenced an objection based upon their review of them. So whether you put that information in or not, that's up to you.
Would it be sufficient to just put
You can leave it blank also, correct, Your Honor?
Yeah, you don't have to fill it in. It can be left blank. If I'm not answering that correct, I don't want you to think you have to put something there.
Yeah, that was my impression. Usually when you're
Got it.
It's the same thing with a job application. You're not supposed to leave nothing blank.
Okay, let me answer it this way because I was not tracking with that one. You only fill that out if there's something specific as it relates to this case that you want them to bring. You're not required to, though.
Okay.
There's a subpoena, and there's what's called a subpoena duke tecum, which means bring something with. If you just want them to come to court and testify, it's just a plain old subpoena. So hopefully that helps.
That is clarification.
All right. I'll address the other issue tomorrow morning. I'll give you some time while you're sitting here to get the subpoenas all filled out so that the state can look at that and start working on getting them served, with the exception of the one that they indicated was out of state, okay? Anything else from you then tonight, Mr. Brooks?
That would be it.
All right. Thank you, everyone. We are in recess. Everyone, court will call State of Wisconsin versus Darrell E. Brooks, case number 21 CF 1848. May I have the appearances, please?
Yes, County Judge Sue Leslie Basie and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in these charging instruments, and I do not consent to or agree to being called that name, Your Honor.
All right, the record should reflect that the individual known to this court as Darrell Brooks is appearing in person in custody. He is also in civilian or street clothing, in a suit and tie, also wearing a mask. Mr. Brooks, I know today you're also not wearing headsets. I just want to make a record. Yesterday, they were offered to you, even charged. The different charging unit was provided. I did not see you wearing the headset at any point in time. And from my perspective, given your either legal arguments made, comments to the court, or questioning of witnesses that you were able to hear, but I just feel it important, given that you raised that issue, to put that on the record. I do want to address the case law that was filed by Mr. Brooks. I have a question, sir, because you had indicated there was this United States v. Lopez. I had looked up a case. I don't know if it's the one that you were referring to. I asked you if it was from 1995. You thought it was. Have you been able to look through your documents to tell me which United States versus Lopez you were referring?
I have not, but I also cited Hagens versus Levine as well, 415 U.S. 533, or I think you may have corrected
I was
that.
able to find Hagens versus Levine and Malo versus United States. I also found a case that is captioned United States versus Lopez at 514 U.S. 549. That's a case from, it was decided in 1995. It had to do with in part, with the
jurisdiction.
No, it had to do with a provision in the federal statutes regarding the gun safe free zone and whether that was constitutional or not. It was a criminal case, but nonetheless, that was one of the major issues in that case. So I don't know if that's the case you were referring or not. And without a citation, it's hard for me to know. So that's why I'm asking you if you have any other information about that case.
I can possibly look on a break, but my understanding of that particular case was dealing with the specifics of subject matter and personal jurisdiction, which is why it was brought up for the record, which is something that I have been doing adamantly, is asking for the court to provide verified proof of jurisdiction, which I have not been provided with as of yet.
Court's not required to do that, sir. I understand what your objection is. It's been noted for the record multiple times. And the previous rulings of the court stand. I see no reason to revisit those issues, or what we call legally a motion for reconsideration, even if I were to take your reference to these cases as a request to reconsider based on a new legal argument. The cases that I reviewed don't support that. I do want to give the state an opportunity to at least make a record as to their position, and then I'll give you the last word if you want to make a legal argument to the contrary.
I do.
All right, so go ahead. I believe Attorney Basie, you were going to do that.
I was. Your Honor, I did review the U.S. versus Lopez, the Lopez case that you cited at 514 U.S. 549. As the court already indicated, it deals with the Gun-Free School Zone Act, which is a federal offense, the court found that that Congress exceeded its authority under the Commerce Clause, and therefore there was no jurisdiction. I don't find any analogy between that case and this case. Again, I'm not sure if that is the Lopez case that the defendant was referring to. With regard to Malo versus United States, this was a case involving an accident that the plaintiff had with an employee of the U.S. Postal Service who was driving a U.S. postal truck, and the issue became whether or not there was a valid claim against the U.S. Postal Service as a result of a claim filed against the employee, and the court held that there was not, and therefore jurisdiction was not conferred to the United States. Again, not a case that is on point with any issue that's been raised in this case. And finally, Hagens versus Levine at 415 U.S. 533. Again, this is one in which the district court was found to have had jurisdiction to hear the plaintiff's claim. It was a case in which a New York, state of New York regulation addressed New York's ability to recoup some payments from AFDC, I believe, and there was a claim that violated the Equal Protection Clause of the 14th Amendment. The court did find that the district court did have jurisdiction to hear the plaintiff's claim. Again, I did not find any verbiage from any of these three cases that would raise any type of argument in this case that this court does not have jurisdiction to hear this case.
Thank you. Mr. Brooks, your response.
Yeah, I respectfully object to that. It's clear in both of those cases that ultimately those cases were called correct by the Supreme Court, and that both cases ended up being voided because there was no jurisdiction. Same thing in this case. How it applies is this court has yet to prove that it has jurisdiction. It has not been proven. There's been no certified document paperwork. There's been no proof. There's been no response to the demand for the statement of particulars. There's been no response to we haven't even established that the plaintiff is a living human being and not an entity. There's so many things that have yet to even be proven. And again, if both cases that were just cited were voided by the Supreme Court for lack of jurisdiction, how is this case any different?
Thank you for your arguments, sir. First of all, the Hagens and the Malo decisions, or Malo, these were civil lawsuits. They weren't criminal cases at all. They dealt with the issue of a federal question or federal claims and jurisdiction in the district court for those particular cases. There's nothing that's applicable to a criminal case in state court for this court to even find they're relevant. They may be case law, may be law as it relates to that, but they're not relevant to the proceedings in this case. In the Malo decision, for example, that had to do with a lack of jurisdiction because the plaintiff had failed to exhaust administrative remedies. That's not something that's applicable here. And so in that case, the court did not have jurisdiction. In the Hagens case, again, it had to do with a federal claim and jurisdiction related to that, and not criminal charges brought by a state against a individual. The Lopez decision, while a criminal case, dealt with a federal law and whether the district court had jurisdiction. In Lopez, the U.S. Supreme Court struck down a federal statute that had made an offense criminal, and because of that, there was no jurisdiction. There have been no similar arguments made in this case at all. The arguments that you raise related to the Bill of Particulars, related to those types of issues have all been debunked throughout the ages in the courts of the United States of America, both in state court and in federal court. And I direct your attention once again to United States versus Benaby, 654 F. 3rd 753. It's a 2011 decision from the 7th Circuit that is very on point as to the arguments that you are raising. So there's no requirement for this court to do what you are asking or demanding it to do. And for all of those reasons, this court will deny your request to dismiss, deny your request for the demand for particulars, even going back to one of the filings from the 3rd dealing with your demand for a verified statement, your notice of special appearance. I mean, all of those things have been noted on the record, but to the extent that the court needs to respond to any of those, once again, your demands and requests and objections are either overruled or denied, as the case may be.
Your Honor, may I respectfully request a legal reconsideration for your ruling?
No, I just went through my reasoning, sir. So without you meeting the standard under a motion for reconsideration under Section 806.07, that request is summarily denied without any further argument. All right, with that...
For the record, may I request a legal or factual basis for your ruling, as you just cited, Your Honor?
I just provided the legal basis, sir.
You just cited a case law from United States versus Benaby, correct?
My reasoning stands. The record before you and on the record speaks for itself. I'm not going to address this any further. Your objections are noted.
Respectfully, Your Honor, may I ask for a written judicial finding of facts and conclusion of law on this matter?
You may request. That request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
That is not an issue this court would address. That would be for an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
That request is denied. This is a court of competent jurisdiction.
Based on what law or fact, Your Honor?
All right, Mr. Brooks, your objections are noted. I want to keep moving forward today.
May I respectfully object to that, Your Honor, based on the fact that you cited something that was a federal law, and then the cases that you went over in the challenge of jurisdiction were all dealing with federal guidelines.
This court's not going to explain the law to you, sir. I've cited the law, but I just direct you to those decisions. I believe they speak for themselves, and your request for any further articulation by this court as to the basis for the court's decision is denied.
May I respectfully object, Your Honor, and still ask for verified proof of...
Mr. Brooks, I've already addressed that. The request is denied. All right, moving on. Can the state... I'm moving on, Mr. Brooks. Thank you. Your objections are noted. Attorney Opper, I'd like to address the issue...
Object, Your Honor.
Your objections noted. I would like to address the issue of the subpoenas that were turned over to the state. If you could just make a record on that.
Yes, thank you. We have received the subpoenas that were provided by Mr. Brooks. I believe there were 12 in total. We are endeavoring to have all the individuals properly served, and we will assist in arranging their appearance here in the courtroom at the appropriate time, with the exception of that one individual who we believe has relocated to the state of Texas. There are no other concerns that the state has at this point in getting those subpoenas served and getting these people here. I do want to advise the court that one of the witnesses on Mr. Brooks' subpoena list does need a Spanish interpreter. And that also reminds me to update the court on our progress in that regard. For the state's case, we believe if we would need a Spanish interpreter, and it's still unknown to us, or uncertain, I should say, it'd be later tomorrow morning, like probably after the morning break, or even after lunch. We could call these witnesses out of order if we had to. So if you want to just say possibly 1 p.m. tomorrow, we could certainly work around that. And then when we get to Mr. Brooks' case, one of his witnesses will need an interpreter as well. We'll try and help the court keep track of that as well.
Can you tell me the name of the witness for Mr. Brooks that needs an interpreter?
Juan Marquez, Marquez.
All right, thank you. I'm contemplating, Mr. Brooks, that since the witness you want is part of that group and there's a possibility that they will need an interpreter, if that's the situation, then I'm going to require that Mr. Marquez be produced at that point for questioning. You'll be questioning him first since it would be your witness, but I want to make wise use of our resource as it relates to the interpreter. It can be challenging to schedule interpreters, especially on a last-minute basis. I know the clerk's office has been working with the DA's office based upon the request that was received. The latest information I have, before I get back to you, Mr. Brooks, is that Kevin from the clerk's office has made a call, but it was not returned. So perhaps you can have your assistant, that was last week, follow up just to make sure we're all on the same page.
Sure. Thank you.
All right, Mr. Brooks, any questions about what I've advised you about the interpreter? Does that change your decision at all to call the witness?
It doesn't change me wanting to call the witness, and I want to state for the record that I object to being called that name. I'm a living and breathing human being. My name is Darrell Brooks Jr. I do have questions though. You're well aware that once we went off the record yesterday, I stayed to complete all of the subpoenas.
I'm aware of that.
There were initially 13, and I believe I turned in 12 because the prosecution stated that maybe one of them had relocated, but there was just a little bit more clarification that I didn't have yesterday about that whole situation, if they relocated or how that would play into them being subpoenaed. So
is there a question as it relates to that, or just you're making that record?
I'm making that record, and also I wasn't sure yesterday, and maybe I should have asked before we went off the record, should I have just turned in all 13 subpoenas that I had and then just wait to see what more information could have been learned from that?
You can certainly give them the 13th subpoena, and we can make a further record later if need be. And we'll go from there. I mean, obviously, as officers of the court, they're telling me that they have this information about a witness being out of state. There's a different procedure for obtaining a witness that is from out of state, including that the person calling that witness needs to make the travel arrangements, and that's in the rules of procedure. So, but it's up to you if you want to turn that one over so that it's officially one that you turned over, given that you had been given that information and then the subpoenas needed to be refilled or filled out again. I'm certainly willing to have that turned over to them, and at a later point, a further record can be made if needed.
If in the event that takes place, would it be the same procedure, me having to stay after, or how would it work from that point? Because I would essentially say it would make more sense to just fill them out all together and file them together, so everything is just together. It makes it easier.
Fill out the one.
Just the one?
Yes. Do you need another form?
I have another form.
All right. Do you have a copy of the first time you filled it out, so you have some of that information readily at your fingertips?
I believe I do. I don't want to say I'm 100% sure. I would have to do some minimal looking through all the paperwork.
If not, I have the first batch of subpoenas on my table in my chambers, and I can bring that out.
I'm pretty sure if it's not in the paperwork that's in front of me, it's in one of these boxes, which, as you see, is a lot of paperwork. I'm positive that it's there. I would just have to.
Well, let me know on a break. Like I said, I have it readily available and certainly can give it back to you to look at. All right. What about did you hear me advise you about the interpreter and making arrangements and potentially calling your witness out of order because of that?
Yeah, I think that was pretty clear.
Okay, good. Just want you to be prepared for the possibility that tomorrow you may need to call that witness, or the witness will be made available and you may need to question that witness tomorrow. So I just want you to be prepared for that.
So that should be the first witness called?
It would be out of order. It would still be during the state's case in chief, but if we have the interpreter here, because they need it, because they're not clear yet if they need that interpreter or not. If they use the interpreter and the interpreter's here, and then I'm going to also ask that they make arrangements to have Mr. Marquez available so that the interpreter, we can wisely use the interpreter resource and call those individuals, if not back to back, within short order of one another. Sometimes we have to give the interpreter a break and a rest. So that's why it might not be back to back. But in any event, you should be prepared potentially to question that witness. If they don't call the interpreter and the interpreter's not here and we haven't made arrangements, then I'm going to work with my staff and the clerk's office to make sure we have an interpreter during your case. You'll just need to tell me where in the 12 you want to call that person so I can better schedule.
In the 13.
Well, you have 13, but one's an out of state, so I'm told. But all right, very good. All right, anything else from the state then?
No, that was it for today, Your Honor.
All right, Mr. Brooks, anything other than what we've already talked about?
Yeah, I don't know if the clerk received 2 ICF forms that I submitted.
I don't know if anything. I can check my electronic inbox. Let me just do that real quick and see if there's anything there.
Well, one of the ICFs we just addressed, that would be the one that I filled out last night, coming back from the proceedings yesterday. We just addressed that. That was dealing with the subpoenas.
Okay. All right. I don't see it. I'll make sure that my staff knows to look for it, and when we get it, it'll be uploaded, and then we can address it at a break.
The other one was dealing with asking for my court docket sheet.
What do you mean by that, sir?
I would like a certified copy of my court docket sheet.
I need to know what you mean by that, sir. There's many documents in the record. There are docket entries that are part of the electronic file.
Is the entire every court proceeding, is that part of the electronic file? What did you just say?
You mean a recording of the proceedings?
No.
Or a record?
I want the actual docket sheet from every court proceeding that I've had in dealing with this matter.
Well, you'll have to address that to the clerk of court.
I did.
Okay, so then that's why it didn't come to me and I wouldn't seen it. I'm not the custodian of the record. It's the clerk of court under the statute. So
was it received?
I don't know, but I can find out. And on a break we can advise. I'll direct Teresa to find out from the clerk of court if she received that. But she'll respond in due course.
It was addressed to Miss Monica Paz.
Okay, that's our clerk of court, so that's good that you did that. All right, anything else then? Other than what we've already talked about?
No.
Okay, very well. State will have its next witness then when we bring the jury out?
Yes.
Okay, very well. Madam Clerk, please have the jury brought out.
You testified a few minutes earlier that you really don't remember much after being struck. Do you recall where you were after being struck?
I was on the ground.
And about which area? Was it by the Blazers truck, relatively close to the curb, or about what position?
Near the truck?
Near the Blazers truck?
Yes.
Did you see the vehicle strike anyone before it struck you?
No.
No further questions.
Thanks.
Thank you, sir. You may step down. Before he's excused, I'm just going to excuse the jury momentarily. We'll let you know when you can be brought back in. All rise for the jury, please. All right, thank you. Be seated. Mr. Brooks, I cut you off when you were asking questions about what this witness had seen on the news. I'll give you an opportunity to give me an offer of proof as to why you believe that's relevant, and specifically as to this witness.
Well, it's relevant because of how close he testified to being away from the vehicle. He testified to being 20 yards away from the vehicle, which is not super close, but it's not far enough that you wouldn't be able to see a driver or see into the car.
Well, so that's an argument, sir. So what questions would you have that you didn't already ask, and how does the news reports relate to that?
Maybe he may have seen the alleged defendant on the news, and maybe that may jog his memory back to if he seen the driver.
But he testified he didn't see the driver. So
he also testified to never making the comment that he didn't remember the event, but it's clearly in his summary and in his report that he said that. So it's conflicting. His report is conflicting with what he's testifying. So I was trying to get at the credibility of it. That was my whole aim.
What does the news reports have to do with that, sir?
The news reports are relevant just by the sheer amount of reporting that they've been reported. This has been going on for a year.
That assumes facts, not an evidence, sir. So this witness did not identify you during this trial. This witness testified as to his observations regarding the date in question, his injuries, and other things surrounding what he saw and heard and what he didn't see and hear. So the news reports don't have any bearing on his credibility. The points that you bring up are arguments that you may make if you choose during your closing arguments. But the questions you were asking don't further that theory. So that's why I cut you off, because there was not anything that you were connecting by way of relevance.
With all due respect, Your Honor, a lot of the questions I ask are objected to. It seems like I can't even get to the questions that need to be answered.
Sir, many of your questions go to these sovereign ideas that are frivolous arguments about the plaintiff and all of that. We give you a little bit of leeway. I give you a little bit of leeway on it. But to ask about a claim, because frankly it's a vague question, and many of these victims may in fact have made a claim with crime victim compensation, and so I think that's potentially relevant, but you may be asking it for a different purpose. I'm allowing it probably for a different purpose than you're anticipating, but the questions about the state and the plaintiff, other than when you talk about and you ask questions about who subpoenaed them, had they reviewed anything in preparation for their testimony, those are all fair game. But other questions are not, and that's why there's an objection, and that's why I rule the way that I do. So ask relevant questions, they'll be answered. So I don't see any need for this witness to be brought back in. I don't believe that witness was on Mr. Brooks's list, so that witness is excused. Who's the next witness?
With all respect, on the record, Your Honor.
I've asked a question of the state. Let them answer, please.
Will I be able
Mr. Brooks, let them answer. Hold on.
So the next witness that we had intended on calling is Detective Mike Carpenter with the Waukesha Police Department, who would provide testimony about his conducting the speed analysis of the vehicle. I don't expect that we'd be able to get through direct. Well, we might be able to get through direct.
I'd like to at least have him start. I want to go closer to the lunch hour today.
So the other issue is that we thought we were going to be breaking for lunch, so he's not in the building right now. We have another witness who is ready, who we could call out of order, but that would be moving into a new topic, a new group along the parade route. So we're fine with whatever the court wants to do.
I'd like to keep going, so I'll defer to you on which witness to call.
And Your Honor, I would just note, I don't believe I asked for it, maybe I did. Jeff Rogers, I know he has remained in the courtroom, he is a victim. Is he excused from his subpoena? He was not an individual who is, who we were provided a subpoena for by Mr. Brooks.
He's excused.
Thank you.
All right, we'll bring the jury back out and you may call. Quickly, Mr. Brooks.
You made reference to questions I asked and being, you said something to the effect of sovereign things. I don't understand what you mean by that. I have no anticipation on your rulings. I'm not trying to sit here and I got enough work to do on the fly. I'm definitely not trying to sit here and trying to anticipate what will be objected to, what will be ruled on in any way. I'm merely just, it was understood that this would be a whole new thing for me to do. I apologize if I'm not as polished as I should be working on 3 days' time before a trial. We see all the work that I have that I haven't even gone through.
Mr. Brooks, the jury's coming back in.
For the record, I don't consent to that name, and I don't consent to the arguments that the prosecution made. There are relevant questions, as the jury deserves
Mr. Brooks,
to know.
Please.
The jury deserves to know who the plaintiff is in this matter. I think it's fair to them, if they're to make an informed and intelligent decision, they should know who the plaintiff is.
Sir, your objections noted for the record.
I ask for a legal finding of fact on that ruling, Your Honor. Or is that a judicial determination, Your Honor?
Thank you, everyone. Please be seated. All right, the state may call its next witness, please.
If you recognize the video. Okay. Now do you recognize the video?
Yeah.
What does it show?
The car going through and someone flying.
Is that an accurate depiction of the scene as you saw it that day?
Mm-hmm.
You're saying she already stated she didn't recognize the video.
This characterizes her testimony. Your objections overruled. It is not hearsay. You may answer. And if you did answer, if you could just repeat it.
Could you?
Is that video an accurate depiction of the scene as you saw it unfold that day?
Yes.
Your answer may stand. Thank you.
What was the answer?
Yes.
Move Exhibit 34 into evidence and request permission. Pause. And I'm going to ask Ms. Gussie to go frame by frame. We paused at 1 second, by the way. Next frame. Next frame. One more. There. We're at a frame at 2 seconds. There's a figure on the bottom, on the left side of the screen, appears to be wearing black with long hair. You recognize that person?
Yes.
Can you see any features
Mr.
in
Brooks,
there?
that's argumentative. Your objection's noted. It's overruled. You may answer.
Hearsay. Objection
Not
for hearsay.
hearsay. You may answer.
Clear hearsay.
You may answer.
Yes.
Who is that person we're looking at?
Jesselyn.
Can you use the touchscreen in front of you and circle that picture? Circle Jesselyn, please. I'd ask to save the annotation as Exhibit 34A and to move it into evidence.
The annotation has been saved. Exhibit 34A is received.
Ms. Kuczewski, when you say Jesselyn, are you referring to Jesselyn Torres?
Yes.
Oh, yeah, thank you.
Thank you. You may step down. She may.
Thank you. The state will next call Jamie Sutton. Are you the first person to testify about speed analysis using the Input ACE software in any court in this country?
No.
Object.
Overruled. His answer may stand.
So when reference was made during cross-examination about this being new, air quotes, software or new technology, is that an accurate description of the technology?
No.
Objection. I was referring it to it being new to him, strictly to
Your
himself.
objections noted. His answer may stand. Next question, please.
Is this this technology, the software program Input ACE, used exclusively by law enforcement?
No, it's not.
Who else uses it?
Accident reconstructionists, insurance companies, defense attorneys, law enforcement. It's available to anybody that provides payment, goes through the training, things of that nature.
That's all I have. Thank you.
All right, thank you. You may step down.
Thank you.
All right, this will be a good opportunity for an afternoon break. I'm going to keep it a little bit shorter, hopefully about 10 minutes for the jury and the parties. All rise. Or 3:30, and how long the state believes the next witness will take.
The next witness is Deborah Ramirez. She is going to take about 10 minutes on direct.
I'd like to wrap up today very close to 4:30, and so if we can keep that in mind. And then I also need to address one other thing, and that is the clerk's office has made arrangements for Spanish interpreter for tomorrow from 12 p.m. to 3:30 p.m. And so I need to know from the state whether they will be utilizing the interpreter.
Well, Your Honor, we can call witnesses out of order. We're behind. I'll be very honest. Today has gone much slower than we anticipated on cross-examination. So, but I understand the arrangements have been made, so we can shift things a little bit and try and accommodate that schedule by the interpreter.
Do you believe you can also have the witness that Mr. Brooks identified needing an interpreter?
Let me check on that during the break, Your Honor.
Thank you. I would appreciate that, because then I would like to utilize the interpreter. The only other request, since we were only able to secure one interpreter, would be to put to have a different witness in between the two so that the interpreter has an appropriate break.
Okay, understood.
And then, of course, it will also require us to be mindful of when we take the lunch hour, since the interpreter is available from 12 until 3:30. So
12 to 3:30.
we may need to take our lunch maybe at 11:30, and I'm okay if we start a little bit later than the noon, but that should give us enough time. Any questions about that, Mr. Brooks?
Again, I'm going to say I don't consent to that name, but no questions.
All right, thank you. All right, we are in recess, 10 minutes. Come back.
Do you recall it being pretty loud out there that evening?
Yes, I do.
Pretty windy, pretty cold?
I can't remember.
It'd be fair to say it was chilly enough to wear a jacket or a coat. Would that be fair to say?
Yes.
Would it be fair to say that maybe it was windy enough to wear a winter cap?
Yes.
Do you recall if you were wearing a winter cap?
I do.
And do you recall if you had it pulled low, possibly over your ears?
No.
You don't recall? I'm sorry, I didn't know what the no was to, that's why.
I was wearing a headband. I was not wearing a cap.
It'd be fair to just say that you just said you was wearing a cap.
No. You asked if I recalled if I was wearing one. I said yes, I recall.
That you were wearing a cap?
I recall if I was, and it was a winter headband.
I might have been confused. I apologize.
Ask the next question, please.
I don't consent to that now, Your Honor, for the record.
What is your name?
Brooks.
First name?
Darrell. For this witness, thank you.
All right, thank you. You may step down. All right, we will at least stop with testimony for the day. I do have the instruction to read to the jury. Morning. All rise for the jury, please. Same thing. All right, thank you. Please be seated. All right, Mr. Brooks, I cut you off because I wanted you to raise whatever the issue was outside the presence of the jury. I don't know if you had a question or an objection or a comment, but go ahead.
I forgot what part you cut me off on.
Would you please show the witness only, exhibit number 40.
Go ahead.
You see the photograph in front of you?
Yes,
Are you in that photograph?
I am.
What does this show?
That shows me getting up afterwards, after the incident.
Is this an accurate screenshot of how you looked after the SUV came through?
Yes.
Move exhibit 40 into evidence and ask to publish.
Exhibit 40 is received, permission to publish is granted, similar to one of the prior exhibits. You'll notice there are some comments on the right-hand side. The jury is instructed to disregard those when considering this exhibit.
Thank you. Could we zoom in on the middle of this, please? Once again, Mr. Ramirez, if you see yourself, could you please circle yourself for us? Thank you. And do you see Isaac in this screenshot?
I don't.
Okay. We can clear that and zoom back out. That's all I have for this witness. Thank you.
Right, thank you.
Quick objection on that last exhibit, because you just said that.
We'll take that up outside the presence of the jury. Don't let me forget. All right, then go ahead if you have any cross for this witness. Well, it had to do with the one of the exhibits, and it's the second time it's happened where I've told the jury to disregard comments that are visible on the exhibit.
Yeah. Is it a way that I mean, because that was the one that was the steel frame, right?
Correct. We've seen it before on the video.
Can they cut that part out so that way just make it easier?
So at this point, the exhibits have been received. I've told them to disregard it. What may happen is ultimately when they're deliberating, they may ask to see exhibits. And if that happens, then I'll have to make a determination about whether those exhibits are given to the jurors. There might be copies that are there or shown if that's the type of exhibit we're talking about, and then we'll go from there. So it's a little bit premature, but I hope that answers your question.
I do believe you were more than clear when you told them to disregard it. So that part was definitely clear. And the worry would be if they were shown that in deliberations.
We'll cross that bridge if and when it becomes an issue.
Yeah, I just don't want it to.
I understand.
Just for the record, we're talking about Exhibit 40. That's the exhibit that Mr. Brooks, the defendant objected to, and that we put on a pause until the jury was out of the room.
It was Exhibit 40, where I instructed the jury to disregard the comments on the right. I have a note. I'll have to look back through my notes on this happened another time, and it may have been maybe the same.
I think it's the video that this screenshot came from.
Exactly. All right. Then, does the state have any information for me about the witness and whether you'll need the interpreter for tomorrow?
No, we do not believe we will need the interpreter for any of the state's witnesses, Your Honor. We did secure Juan Marquez to be here at noon, so that as soon as we start from the afternoon break, we could take his testimony out of order.
All right. Mr. Brooks, do you understand that?
No. But
well, let me advise you, sir, that since there's the need for an interpreter and this court had been going through making, not myself, but the clerk's office, to make arrangements as it relates to this interpreter, I'm going to have you call that witness. It will be out of order. That's not unusual. That happens sometimes, but we at least have that witness available starting at noon. If all goes well, we'll take an early lunch about 11:30. We'll take an hour, and then we'll put Mr. Marquez on at 12:30. You'll do the initial questioning. The state will then do the cross, okay? Did you hear me advise you of that?
I'm informed.
All right. And then the other thing I just want to put on the record today is that, again, Mr. Brooks does not have the headphones on. I did not notice any apparent difficulties with your hearing. I wanted to also make a record that, especially as it relates to the cross-examination of Detective Carpenter, which I would describe as a technical expert witness, there was some very articulate, clear, cogent, and salient questions were asked by Mr. Brooks, especially regarding when the technology was obtained. He questioned him about such topics as it was a live case and what that meant, the reliability of the software, the equipment, even the financial issues, not issues, but just how it was obtained, his training, his experience, asking questions regarding did he provide, for example, speed analysis for any other cases and things of that nature. You're certainly questioning other witnesses about whether they've watched videos previously that would go, to their credibility, which is ultimately a jury determination. But I just wanted to put that on the record and commend you for that. Any other issues from either party today? From you, sir?
We still got the issue about the 13th subpoena.
So my understanding is you filled it out, or do you need to fill it out?
It's been filled out. I just wanted to know I didn't know when it was going to be addressed.
So
And
my understanding, and let me confer with the state, did the subpoena get turned over to the state? The 13th subpoena.
I don't believe it has, no.
It's the witness is the one who the state previously advised us lived out of state. That's the person we're talking about, correct?
and that's the issue.
So the state's not obligated, I'm just going to cut to the chase. The state's not obligated to make any kind of travel arrangements or otherwise serve the subpoena on someone who's out of state. There's procedures in the statutes. I'm not going to lay those out for you. This is one of those things. I'd refer you back to when we went through the waiver of right to attorney form and about how the court can't explain procedure or the law, that you're put in the same position as an attorney who's been practicing here in the state of Wisconsin. I am not going to require the state to make arrangements for an out-of-state witness. That falls on you.
For the record, I have to be licensed to be held to the same standard as a licensed attorney. I don't want to get into that because I don't want you to think I'm trying to argue.
I disagree with your legal assessment, sir. So your objection's noted for the record. But you're a party to this case, sir, and parties that are self-represented can do things that attorneys can do. A party doesn't need an attorney, for example, to secure a subpoena. So with that, I believe that addresses the 13th subpoena. Any other issues?
I intended to have 13 witnesses. So if I'm obviously not able to call the 13th witness, how do I get my 13th witness?
I can't answer that, sir.
Would I still be able to have a 13th witness?
You have to name the person. The due date was on Monday. So who would be your 13th witness then, sir?
I would have to look on my original witness list to get the 13th witness. I know that was my target, was 13.
Well, I'll tell you what. I'll let you look through that tonight, and you can advise us in the morning, and if the state wants to object, they can advise me then. But you're going to have to fill out another subpoena then.
That's fair.
And
that's fair.
I can't promise that they'll be able to do that, but we'll see what they have to say tomorrow morning.
Yeah, I do want to state also for the record why I'm able to hear you very well is because I'm actually in the courtroom with you, which I have been the last few days, which is a breath of fresh air.
I would agree with that assessment, sir.
That's why I'm able to hear much more clearly.
All right, thank you for making that record. I appreciate it. Any other issues from the state?
Nothing, Judge, thank you.
All right, we'll see everyone then tomorrow morning at 8:30. We are in calling State of Wisconsin versus Darrell E. Brooks, case number 21 CF 1848. May I have the appearances, please?
Morning, Judge. Sue Daisy and Zach Woodchow appearing for the state.
Sir, would you please state your name for the record?
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
Right, the record should reflect that the individual known to this court as the defendant, Darrell Brooks, is present in court. He's in custody, but he is wearing street clothes. He's wearing a suit and tie and a mask. And good morning once again to everyone.
Also for the record, I do not identify by that name or consent to being called that name. My name is Darrell Brooks Jr.
So noted. All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick. Mr. Brooks, I'm reviewing this for completeness, and you have simply put on here, State of Wisconsin plaintiff. That's an entity. You have to name a person, sir. The date. Well, the date we would fill in. So I'll have it shown to the state, and they can let me know their position on that.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff for the witness name. The State of Wisconsin is an entity. It's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the State of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the State of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you have named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the State of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not, or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that they...
Sir, you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the State of Wisconsin. And with all due respect...
Sir, I believe your Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can a claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm also not going to issue a written decision on that. The record speaks for itself.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you have been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir. So based on law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or fact?
I'm going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And without
Mr. Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right.
I've already addressed this. Okay, we're not going to have any further argument on this topic. All right, your Sixth Amendment rights are being honored no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the claim, Your Honor.
Sir, it's my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've directed your attention once again to the Beneby decision.
Is that not a federal case, a United States?
You're asking me for legal advice. I'm not going to provide that to you, sir.
I'm just asking what kind of case it was. Was it federal Supreme Court case?
It's a Seventh Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
But you just stated that you're not a court of appeals. But you're citing a court of appeals case.
No, but Court of Appeals case law applies to this court, sir. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser, which is my Sixth Amendment constitutional right.
Sir, I'm not going to explain the law to you. I've made my decision. It stands.
I'm not arguing that part of it, Your Honor. I'm just merely stating for the record.
Yeah, I heard the door. Okay, thank you.
I'm merely stating for the record that I should be awarded my Sixth Amendment right to face my accuser.
Your objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses that testify are the accuser. None of the witnesses that testify are the injured party, which a claim has to be made by a living, breathing human being.
Sir, I think you're confusing civil law with criminal law. That's what I'm saying.
No, I'm confusing. I'm not confusing any law. The Constitution says that I have the right to face my accuser. And under the Sixth Amendment, I'm not being awarded that constitutional right. I think that definitely needs to be on record, and that definitely is an issue that needs to be raised.
Your objection is noted, sir. If you believe I've erred in that regard, you can raise that issue on appeal if you are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
Your statement's noted for the record.
Is that a judicial determination I will not be able to face my accuser, Your Honor?
I have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made any kind of determination that your Sixth Amendment rights have been violated. On the contrary, I believe this court has honored those rights.
Even with me not being able to face my accuser, which is the state of Wisconsin.
Your position is noted, sir.
Is that
noted for the record. I've already addressed it.
Is that a judicial determination?
Sir, the record speaks for itself.
Is that a judicial determination?
All right. I believe the jurors are coming out. All rise, please.
Are you going to answer that, Your Honor? Or is that a tacit agreement?
I'm not going to answer that further. I've answered it multiple times.
Is it a tacit agreement?
It is not.
Then I should be awarded my Sixth Amendment right to face my accuser. Or a judicial determination should be made.
Record to reflect that the jurors are coming in for the morning. Good morning, ladies and gentlemen.
The record should also reflect that I received no answer to that question.
And good morning to the remaining jurors who are filing in. Of course, we stand for you, so when you come in, you can have a seat. And thank you, everyone. Please be seated. State may call its next witness.
Thank you. The state will call Stephanie Bonesteel.